Thank you, members of the press, for this very effective coverage from the time Ian Njoroge was arrested to the time he was arraigned in court on the 5th day of June in this year of our Lord 2024. Ian was charged with 3 counts. The first count was on robbery with violence. The second count was assault causing grievous bodily harm. And the third count was resisting arrest. When he was arraigned, the prosecution made an application that they wanted 3 days to oppose bail and bond. We argued against that application, and in all fairness, the court granted them 1 day. We came back the next day, and we were able to substantively argue out why Ian was to be released on bond and bail. And the state had refused that Ian should not be admitted to bond and bail for reasons that, one, the offense that he created was so serious that if he is released, he may not attend court. Secondly, that Ian was, or most likely would have interfered with witnesses if he were to be released on bail. And thirdly, that it would pose danger to Ian because members of the public were in agitation against him. Of course, as the defense counsel, we opposed, and our first bone of contention, and for the benefit of the Kenyan public, the High Court declared that the wording of the offense of robbery with violence, as it is in our penal code, is unconstitutional. And therefore, no prudent prosecutor, no prudent state should charge any Kenyan for robbery with violence before the Attorney General amends our criminal statutes. We are happy that the court appears to have agreed with the defense that the coaching of that particular offense was declared unconstitutional. And therefore, the court proceeded to determine the application based on the second and the third charge. The court has dismissed the arguments by the prosecutor that Ian can interfere with witnesses and said that the prosecution has not presented before court cogent evidence as required by law. The court has further dismissed the state's allegation that if released on bond or bail, Ian will be in danger of being attacked by the public. And the court has reiterated the argument by the defense counsel that it is the responsibility of the state and the police officers in terms of Article 29C of our Constitution to provide security to all citizens, Ian Njoroge included. As such, the state argument has been rejected, the application has been rejected by the court, and Ian Njoroge has been admitted to a bond of 700,000 shillings. What this means is that Ian's parents, relatives, or friends can deposit something in court worth 700,000 shillings, either a title of a plot or a logbook to a vehicle or a pay slip that is of such magnitude in terms of the shares in a SACCO, and Ian will be released. But because the court sat up to 3 and there is a procedure of confirming whether the logbook or the title is authentic, we undertake to process it over the weekend, and on Monday morning we will present the surety documents to court and Ian shall be released. It's also imperative to note that the medical report has been availed to court as had been requested, and it is quite damaging. They have confirmed that Ian has a fractured jaw. Ian was assaulted badly by the police officers. In terms of the report that has been deposited, it is a matter that the defense counsel will not take lightly, and we intend to file a constitutional petition against the National Police Service Commission and equally charge the respective officers that assaulted Ian while in remand of assault causing grievous bodily harm, among other charges that we intend to bring forward against these officers.
So as we speak right now, Ian is going to spend like the whole weekend in jail up to Monday.
It is 4:10 p.m. as we speak. We are doing our best. The court has given us up to 6 p.m. this evening, so that if we are able to process the surety documents, we process and deposit in court and have Ian released. If we shall not be able to meet the timelines by 5 p.m., the only other working time will be Monday morning. And the problem with surety is that if it is a title document relating to a plot, the valuer must value it at 700,000. Having valued it, the DCI and the lands registry must confirm that the land is authentic. Because we've had cases where accused persons have brought documents that are not authentic to court and secured bail. If it's a logbook, we must get some report from NTSA affirming that the name appearing on the logbook is indeed the name of the owner. Be it as it may, my colleagues are already out doing their best to ensure that we beat the 6 p.m. deadline. But if that will not happen, then Monday morning we'll secure his release.
Mr. HS, are you able to expand more on the medical report?
On the medical report, I'll expand on the face of it because one, I'm not a trained medical doctor, but the language in which it was presented, it was the language of the court that an ordinary layman in medical terms like myself will understand. And the doctors are saying that Ian has a fractured jaw, that Ian had marks which were showing assault. And from the time Ian was arrested to this time, he has been under the custody of the police officers. So the presumption is that Ian has been assaulted by the police officers handling him. When we raised that matter on the first court appearance, because we had physical marks on Ian's body, and we raised to the court that Ian was being tortured at the police station, the officer who presented Ian simply said that Ian had been beaten by other inmates, other prisoners. And the question is, who bears the responsibility? Every prisoner, every remandee in the GK prison is under the care of the police. So if the police allowed the other prisoners to beat Ian, they would only have done that on the instructions of the police officers, knowing that if they did themselves, they'll face the law. But I want to assure them that even if they used other prisoners to assault Ian, the responsibility will still rightly fall on them, and we are going to pursue them to the bitter end. It's also good to mention to the media that we've brought it to the attention of the court that some of the officers who are involved in arresting Ian were caught in a robbery incident, and as we speak now, they are taking plea for robbery with violence. This betrays our argument that the criminals are out here and the innocent are in prison as we pursue bail.
So Ian has broken his jaw and his wrist. Is he receiving medical treatment?
He has been receiving medical treatment in the past 3 days at the Kenyatta National Teaching and Referral Hospital. But as at today, he was released because now what Kenyatta can do, they can give you that preliminary report. Again, he has to go back now for specialized treatment. We have identified the problem, and the problem is that he has a broken jaw. We now need to take him to a specialist.
All right.
Maybe, did you expect that kind of bond or something closer to that?
In all fairness, the state had mounted a very dramatic opposition to release of Ian on bond and bail. We are happy that the court found their drama to be unnecessary without legal and factual basis and granted Ian 700,000 bond. We had advised the family that a fair court in the circumstances will give 1 million bond. I was personally surprised that it came to 700. That shows how fair our judicial system is.
Maybe how was the whole process, the whole cases? Maybe there are things that have been delaying, that have been pushing this case up to this particular day. Maybe how was the whole process?
The whole process, the state was determined to punish Ian before the trial because they know that these accusations are founded on quicksand. They know that this case is not going anywhere. So they were determined to have Ian in remand for as long as it takes. That is why on the first day, they were requesting for 3 days to author a 5-paragraph affidavit. The court rejected that argument, gave them 1 day. And today they come, they are told that they were supposed to present a probation report. They're asking for 7 days to present a probation report. We are certain that even if they had been given 7 days, they would have come with another excuse so that Ian suffers before the trial begins. But that has been cured by our constitution. We have a progressive constitution that protects the innocence of every accused person until they are taken through a trial process. They are necessary and uncalled for applications by the defense in terms of extension of time is not only evil, but an affront to the spirit, the letter of the law of our constitution.
How has it been fighting for Ian as his lawyer?
It has been quite nice, and I actually bumped into Ian in this court when the police were harassing him. I had not intended to represent him. My case was coming up in the same court, and I saw police officers trying to frustrate an innocent Kenyan, and I told them off. And the father requested me to come and support Ian in this matter. I have only spoken to the father once. I can't remember him with certainty. Can't remember the mother with certainty. I'm doing it out of passion for the protection of human rights. Is in law what we call pro bono, helping a suffering soul for free. These are the small things that when we go to heaven, we'll tell God, even though we were drunkards, but we help people like Ian, give us a seat in heaven.
So it is not quite clear why the car that Ian was using before was held. But today in court you mentioned that it should be released. Maybe if you could expound on that.
You know, when Ian was arrested, they picked the car, and the argument was this car is part of the exhibits to be used in court during trial, that it was the venue of the robbery with violence and assault. It is straight law in our criminal procedures that once you have processed an exhibit, you release it back, unless you want to bring it to court physically. The car will not be brought to court physically. We've been following up with the issue of the release of the car, and the OCS tells us, together with the prosecutor, that they are yet to take photos of the same car. What is required in this matter is to take a photo of that car and present it to the prosecutor. So in 5 days, the entire state has failed to take photos of this particular car. They are asking for 1 more day to take the photos, process the car, and have it released. We brought it to the attention of the court because the police force does not understand any directive, unless it comes from the court. So it has gone on record, and the court has ordered that car be released to Ian's mother. The car is registered in the name of Ian's mother, who is not party to these charges.
And maybe my last question, if you fail to present what is required right now, what is going to happen to Ian?
He will be in custody until Monday.
Maybe winning this case against these particular lawyers, I think there were 3 lawyers, right? And we understand that there is lawyer, someone called, this name is called Omar. Winning something, a case against that particular person who has been known all over Kenya. How does it feel?
It feels good. And Dunstan Omari is my contemporary, not in terms of age, but in terms of professionalism in many ways. Omari is a teacher. Think of geography and history. Started as a teacher of geography and history. I started my career as a teacher of English and literature. So both of us are teachers. And both of us are teachers of law. Omari has taught at Catholic University. I teach at the University of Nairobi. Omari and I are in several matters, unfortunately, against each other. In Kakamega, we have the defamation case of Boni Khalwale versus Cleophas Shimanyula. Omari is with Khalwale, I am with Cleophas Shimanyula. In this matter, Omari is with the state, I am with Ian. And it feels good in law, just like in football, to beat your opponent and your brother once in a while, and pray that you continue doing that way in the lifetime of your profession.
All right. Thank you so much, sir, for your time.
Thank you so much, Mr. Chas.